Non, moi, je suis un Eji. Eji, pas sûr. Ready? Very good afternoon to members of National Assembly, panelists, clerk and deputy clerk. It's been brought to my attention that the meeting is really informal because there's a bit of distractions. I've had a few calls, but again, I will say, like I mentioned in chamber this morning, it is an informal meeting. This is why we are not in chamber and we are here. There might be a few distractions where the public out there will see members maybe on their phones or talking to each other and all that. This is normal. Okay? And I'll say this in Creole. Il y a des distractions qui membres publics de au pouvoir à cause de meeting qui est informel. C'est ça la raison qui nous fait là. Il y a un moment côté un membre pour capable sortir peut aller ou il peut prendre son téléphone. Il peut answer a query ou bien il peut prendre une clarification from son constituents, peut causer un petit peu avec camarades par côté, mais c'est sa raison qui nous fait ce meeting comme ça. Il est vraiment informel, mais pour nous capables de gagner interaction avec panélistes, la loi qui est devant nous. So, we will kick off this afternoon with Articles 15 to 18, legal personality and capacity.
15 to 143.
15 to 143. Yes, sorry about that. Yes. Okay. Professor, shall you lead?
Yes,
please.
I'm happy to do so.
Thank you.
Mr. Chair. This we have four articles, and as has been indicated, there are a number which are vacant for reasons discussed earlier. In particular, between Article 103 and 119, those provisions have already been removed, and they're in a separate act called the Presumption of Deaths Act. And that is one of the statutes which has not been reintegrated into the code. And perhaps I can say a bit more about that when we come to the marriage provisions. Why have some been brought back and why have some been left out? We have here four provisions. One is new, that is Article 15, and the other three are a bringing together of current provisions, essentially in Articles 388, 476 and 488. So if people are interested in the current law, you will find those provisions, and they relate to capacity. When is a person an adult? When can they marry? In the old system, if they were emancipated before they were adult, then of course they could marry even though they were not adult. Those matters, those things have been gone with history, and we are left still with the question of what is the age of capacity, what is the age of adulthood, and those are the matters dealt with in 15 to 16. The provision on capacity in the Code of 75 was 21 years of age, and that was amended by the Age of Majority Act, which said 18. as standard age for adulthood, and that is consistent with the Convention on the Rights of the Child. So that has been maintained, repeated in Article 17, and you'll see in the consequence bill that the Age of Majority Act is one of those repealed. It had one line, it said the age is 18. That age of 18 is gone in here where the old age of 21 used to be. We haven't changed the law, but we believe that this is more orderly. In the marriage provisions, pardon?
Can I just ask a question?
Yes, Honourable Afif.
Just a clarification. When you said there were some sections 90 to 140 which have been removed and put under a different act, which act is that?
Presumption of deaths.
Presumption of death. But that is not one of the legislation that has been presented yet.
No, not changed.
We're not bringing it back.
Are you not bringing it back under presumption of death?
Yes.
So it left the code, went to the presumption of death, we're not taking it back.
Okay.
Yes.
So you haven't changed anything?
No, no. But it does mean we've got a series of numbers vacant. Yes.
Yes, Honourable Ron.
I just wanted to ask a question in relation to somebody who is under 18 and who is married, who is considered an adult. We have an issue here in Seychelles regarding girls who are under 18 being able to have access to contraceptive because they haven't reached the age of consent.
Yes.
With 17, does that mean the person who is married and who is under 18 automatically becomes a person who can give consent to herself in this case, to have access to contraceptives?
Professor, if I may add on this, if we terming 18 and above as adult, it means anybody below 18 is a minor. Now we've got an issue also. I don't know what the law states at the moment. Do we allow minors to enter into marriage?
Yes.
That's another issue.
Yes.
Yes, Honourable Peter.
Which is that provision?
Yes, I would like to raise to also for us also to flag this point, and maybe the AGs here we can clarify. So 16 prescribes that a minor is a person under the age of 18 who is unmarried. So following on the question which the leader of the opposition has asked, 17B then makes a provision that an adult is a person under the age of 18 who is married. And then if you follow on and you look at 144, it says that a minor can contract marriage. Why were those provisions not touched in the revision which was presented to the code, or why are they still in the code today? It doesn't make sense because at what age are we considering here that person as a minor should be able to contract marriage? Should that not be one of the provisions that, even though the committee did not look at, that we should look at? What was the mindset of the committee for not considering reviewing those provisions currently?
Okay. Professor, you want to tackle?
Yes. Thank you. As you say, the basis on which a minor, a person under 18, may get adult status, which comes back to the earlier question, is if there are serious reasons. That's 144. There are serious reasons provided before a judge in chambers, judge of the Supreme Court, serious reasons to authorise the marriage of a person who is under 18. I need to look up the reasoning of the committee on that, but there was considerable debate. It was regarded as a serious matter, but there were examples given where it was thought in the interests of the child, perhaps, that usually there is a child in the offing, that the marriage should be approved. The specific reasons I will endeavour to find.
Yes, Honourable Pillay.
I know that the argument that will be thrown back at me would be about emancipation, whether the child is emancipated, but still it doesn't fly. I don't know how the other members here feel, but I think we need this needs to be explained to us clearly what exactly we are trying to get at, because we were very clear on providing provisions and reasoning for establishing precedents when we discussed court procedure. Why are we not clear here in establishing what those reasons should be? I feel that it is my opinion that this clause has been overlooked and that we need to seriously consider it given the kind of cultural context which our country has.
Thank you, Honourable. Honourable Ram Kalawan.
Mr. Chair, I'm having problems with the marriage of minors. Why? Those of us who sit as members of the Pan-African Parliament and also members of SADC-PF, we are fighting child marriages, and furthermore, we're talking of the protection of the girl child. And I know it does not specify that it's only a girl who can, I mean, we're not talking only about girls, but given the context, we know that it's usually a girl who is involved. And if we are to follow the debate which is happening on the continent, and also of incidents which have happened on the continent, I mean the latest, the Sudan issues, should we not use this opportunity that we are being given to put an end to the marriage of minors, and basically say a minor cannot contract marriage, full stop? I mean, this is,
Don't even provide a door.
No, I don't think we should. If we're talking of the protection of the girl child, then we should close that door, because I mean, what would be exceptional circumstances? I mean, I would like to know what would be the exceptional circumstances, because right now I have problems, especially that we are in the process of, we will also be looking at marriage, where a non-civil marriage, a ménage relationship will give the right to inheritance, to all the protection. So, I mean.
Okay, thank you, Honourable. Honourable Adere. Yes, go ahead.
Thank you, Mr. Chair. in line with what we are discussing now, I also feel that there is an issue with regards to child marriage here. And if we go on further, it states that a judge in chamber can condone such. And it does not really states the reason. It just says 149, a judge in chamber may on production of proof to the judge's satisfaction that there is no impediment. So my concern is, will the child be able to provide proof that there is no impediment to the judge? And isn't that, yesterday when we were discussing in the Bills Committee, we wanted to bring more clarity and more certainty to laws, especially this one that we intend to pass in the future. But isn't that bringing more problems? Like, let's say a mother says, my daughter will not marry. And the girl, who's let's say 17, having been promised Lexus, having been promised whatever the case may be, goes to a judge in chamber to condone such marriage. We are creating more problems, I think, with regards to this. There'll be more problems. And in line with the Pan-African Parliament, we are creating more problems, but we need to be certain of what we are doing with regards to this one. I think it needs to go on the back burner for a while so that a lot more discussion could go into it before it comes before the Parliament.
Okay. Honorable George.
Thank you, Mr. Chair. I'm ambivalent. I really don't mind one way or the other. I think the door has been left here for a particular reason. There may be a case where, let us say, the child is 17 years and 9 months old, the girl, and she's pregnant. Okay, and it may be that this might be a particular reason, a serious and exceptional reason for allowing marriage. You will say, well, why don't you just wait another 3 months? And that would be a valid argument. But I think it's well. Let me say this. Let me say one thing. This provision is exceedingly rare. In 40 years of practice, I've done it once. I've had to go to the court once to get somebody's permission to get married, and the court, after a long and hard consideration and talking to the social services, etc., granted permission because she was pregnant. And it was abhorrent to the family that somebody who was pregnant should conceive a child without being married. So for that reason, the morality dominated over any other issue. Once. The Chief Justice was telling us when we were reviewing this that she has never come across one. So it's exceedingly rare. And as I say, it's so rare that whether it's in or not, it doesn't change very much. What we must never forget, though, is that if two people below the age of 18 cannot marry, but they can certainly live together and have sex, and that we cannot prevent.
Honorable Basilwawa.
Thank you. Mr. Chair, when I look at the present provision of the law, the Civil Status Act, which presently deals with the issue of marriage, when I'm looking at Section 40 now, even though I can see there is also Section 46 and Section 47, my reading of these provisions is that presently, a girl of 15 years of age can contract marriage without the consent. A girl of 15 years of age. Whereas a male person must be 18. So there is this discrimination presently. And so we have to bear in mind what the present provision of the law provides in respect of contracting marriage. And now we look at what the amendment is proposing. The amendment is actually a bit more restrictive than the present provision of the law, because no, the wage, no.
I think 15 and 18.
Yeah, 15, 18, yeah, without the consent of the parent. And that Article 144, the way it's been drafted, or the proposed draft, is such that it is making it more difficult for minors to get married, be it a girl or be it a boy. Mm-hmm. So it is now saying that a minor can get married only if a judge allows it for serious reasons. Okay? But having said that, I do, to a certain extent, share what Honorable Omkalawan has said, that maybe we should shut this door altogether, that minors should not get married. Because when I look at other provisions of the law, in fact, I was having that discussion earlier during the break with Honorable Henri. For instance, under our employment regulations, we are saying a minor can get married now, I mean under the amendment, with the authorization of a judge. But we also say and provide in our employment regulations that minors under the age of 18 cannot work in hotels, in nightclubs, and so forth. So we're protecting them in one aspect, but in the other aspect we are opening the door. So I believe we should be consistent in our law. And for us to be consistent, I believe we should just prevent minors from getting married.
Thank you, Honorable. Honorable Henri.
Thank you, Mr. Chair. Good afternoon, everyone. I tend to agree with the position taken by the leader of the opposition. I mean, it's 2018, and international organizations like UNICEF is appealing to the world to sort this issue of child marriage across the world. Many countries still have it on their statutory book. But I believe that now we've seen the age where children can stay in school. It's up to 17 now, if I'm not mistaken. 17. So we are at a crossroad where we're having a lot of social and moral issue in this country. So as a National Assembly, I believe that we should send a message out there that we should encourage our children to stay in school as long as they can. They have all the support now that they need to have, so I don't see. In fact, Honorable George has mentioned that it's a very rare, but I don't think we should open that door. How can somebody get married, but yet you can't vote because you're not 18 yet? You can't consume alcohol because you're not 18 yet you're a married wife or husband. So it doesn't make sense for me, and we have to harmonize the laws that we have right now. Thank you.
Thank you, Honorable Henri. You're right.
But Mr. Chair, sorry, okay. But the only contradiction in the midst of all that is that the amendments that we are making to the Civil Code is giving a ménage relationship greater importance than marriage. Because here we are saying marriage, I mean already we have problems, cannot contract unless you go to a judge as it's it. But a ménage, it's okay. And later on, I mean, part of the discussions which will come up, I was having with Wao, was that when we will look at a ménage, you'll be able to have 2 or 3 ménage relationships, but the law still says it is a monogamous society. So, a ménage, yeah, have 3, but what if this guy wants to get married to 3 women? He will not be allowed to. But a ménage, it's okay. Yeah. Monday to Tuesday, you're there. Wednesday to Friday, you're there.
Don't elaborate. Okay, Honorable Sébastien Pilet.
Yes, Mr. Chair. Honorable Wao raised the point, and again you see there's an inconsistency between what the Civil Code will now be saying and what the Civil Status Act is saying. So, with the consequential amendments that were being made, given that even in the Act here, in the Civil Code, we were providing for a prescribed consent, in fact, from a judge, this means that the Civil Status Act is inconsistent with the Civil Code, because there is no consent provided for in the Civil Status Act. I stand to be corrected. And then my second point from the legal perspective here, according to this, then the person who is married at the age of 18 is an adult. So the minor can be what? Age 14, 15, 16? So let's take a minor age 14. If that minor commits a crime, for all intents and purposes, according under the Civil Code, that person is an adult. Is an adult. So I think there are too many inconsistencies that we need to close that door, because it says here an adult has full legal capacity. So are we going to come to an agreement this afternoon that we remove this provision from the code?
Thank you, Honorable. I'll respond to AG.
Not that I agree or disagree with keeping or maintaining or removing this provision, but I think we need to be alive to some of the points that Honorable Georges has said. For example, in case of death, somebody is about to die, and he is 17 years old, for example, and he has fathered a child, and he wants, although we're trying to depart from the famille légitime and the equalizing the rights of a child, that person or a member of his family or the prospective spouse will go to a judge sitting in chambers and say, look, there is a serious reason why I would like to have a marriage articulo mortis to sort of legitimize my child. Unless we put a certain limit, for example, 16, not less than 16, something to this effect. But there are other reasons, for example, in case there is a child at stake, and that person wants to have the child born within wedlock. There is a pregnancy. There are many, many reasons why, to save the family honor, as Honorable George has said. There are some families, for example, who feel that marriage is very, very important. And it would, whether the church, for example, will celebrate a marriage of a 17-year-old to another 17-year-old or 19-year-old or 20-year-old. So there, and you go before a judge sitting in chambers. The judge is the one who will decide whether there are serious reasons to celebrate the marriage or not to celebrate the marriage. And furthermore, as we said, you may start a homenage relationship at 17. You may cash in terms of your number of years that you will qualify for you to get property if those provisions are. But you deny somebody from cashing in and to lead a married life. Now, it's not that I'm for or against. It's just there are things that maybe we need to toy. There are ideas that we need to toy with before we take a decision on this issue.
I think one point that we will actually ponder on also will be this thing about legitimate or illegitimate child. When he mentioned that about a girl getting pregnant and then you're bound to marry for, yeah, but if the person, okay, if you put it the way Honorable George has actually put it, the girl is 17 years old, 9 months, pregnant. The father has taken his responsibility. 3 months down the road, the girl turns 18, even if the child is born 17 years, 9 months, the father declares the child and marries 3 months down the road when the girl is 18. So where's the harm?
Yeah,
okay?
But exactly, this was my point. The father, and especially the fact that we will also be looking at inheritance. The father can recognize the child, and even go further to make a will or whatever, and give everything to to the child. So I don't, or even to the, if the father is on his deathbed, the biological father of the child is on his deathbed, but just within the limits of being able to make a will, which will be acceptable in any court of law, then I don't see what the problem is. I just don't see what the issue is. No, my issue.
All right, Honorable Ade.
You see, Honorable George has stated that this has happened once. What is the problem then?
In my career.
Sorry?
In
his career of 40 years, this has happened once. Where is the problem? Why do we want to codify it to say that, okay, all the S4 students go and get pregnant, and now you will go before a judge, and these circumstances which has not been laid before in the law, the judge will find a circumstance to allow you to get married. On your deathbed, articular mortis, if this case happens, why do we want to codify it when it can happen? And that would be exceptional circumstances. But if this exceptional circumstances is placed in the law, then one would know no other reasons other than this one would be acceptable. You see, but otherwise the way it's being left now, it's like anything under the sun, as long as it is justifiable, the judge may in chamber make such an order. I propose that we just leave it out as it is now. If it's functioning, let's not codify it to give it force of law, so that somebody says. And then, you know, a young girl would go to her parents and say, you see, I want to get married at the age of 17, and the law says that I can. So now I'm going before the judge. I send you to H, and I go to the judge.
H-Hotel? Yes, H-Hotel. If you can afford it.
Okay, yes. Professor?
Yes, two brief points. The comment made by the Honourable Pillay, in the consequences, sections 40 to 79 of the Civil Status Act will be repealed, and those are precisely those that are here identified as 144 to 164. So that contradiction won't be there. The second point is that this is an historical provision. So, as has been mentioned by the Honourable Waro, excuse me. There are three potential provisions in the existing law. So it's not a proposal to add something, it's for the Assembly to remove. And I think in terms of the removal, the sense of the historical provenance is important because it dates back to times where the main asset was land, and there were substantial distinctions between the rights of the child born of wedlock and the child born out of wedlock. Now, those historical reasons have gone. They are not there. So the justification for retaining, and it is retaining that provision is, at best, I would say, a moral one. If there are such extraordinary circumstances that the Assembly would feel there could be such extraordinary circumstances that an exception might be made. But the reason it is there from 1804, 1808 for Seychelles, relates to legitimacy and land rights. Chair?
Yes, Honorable Pillay.
So, based on Professor Angelo's comment, does that mean that 147 also, which had historical connotations, specifically 147, that stays there, right?
Yes, that is.
But what about 147C?
That is current,
Yeah.
and that is a different reasoning for the retention, and that depends on community views about incest, basically. So, what is the limit of prohibited relationships, and then at what generation do you say there might be an exception?
Okay, can we, yes, Honorable George?
I was going to suggest,
Yes.
I was going to suggest, Mr. Chair, since we've already crept into
Yes.
144,
Yes.
perhaps the professor could guide us the next portion from 144 to 210, which is marriage, which is to do with marriage. And you can tell us where this comes from, why it's here, and why the rest of the Civil Status Act is not here.
Yeah. And we'll leave any amendment in 17 to the Assembly, to the floor.
Yes. What the Bills Committee will do is it will propose in its report that 16 and 144 be deleted.
16 or?
And 144, because these are marriage of minors.
Well, you would still need a minor as a person under age of, it's
Yeah, part of 16.
just the last phrase.
The last part of 16, yes. And 17B.
17B.
Yes.
17B.
Yes. Thank you.
Okay. So we, okay, Honorable Pillay?
Yes, since Honorable George has proposed that we, Professor takes us through 145 up to the other articles, to 10, I just wanted to see whether any other members had any comments to make about a man and his niece, or a woman and her nephew, with the agreement of a judge in chambers getting married.
Okay, we actually on these articles right now, eh? Okay.
Yes.
So, yes, Professor, please. Yes.
Yes, thank you. The next tranche, so to speak, of the articles are 144 to 210, and the discussion has already moved into this area, which is marriage. A quick word about why, in this case, we have the marriage provisions of the Civil Status Act brought back into the code, whereas the 5 or 6 provisions in the code, which still relate to absence and presumption of death, have been taken out and put with the Presumption of Deaths Act. And the reasoning was this: if the core principle, the starting point is they were all in the code. They were all in the code. If now we find that the core principles are still in the code, even though there are supplementary provisions elsewhere, the general pattern was to say, put them back into the code. Where there was substantial provision made elsewhere, as for the presumption of death, the main principles are in that other act, and the goal was to integrate them. Now, interestingly, in respect of marriage, if you look at the current code in Article 203 says the spouses together undertake the obligation to maintain and bring up their children. 212, the spouses owe each other faithfulness, support, and assistance. 214, the husband is primarily responsible for the family charges. The current code doesn't mention marriage. So the thought was, here you have core obligations of marriage. Shouldn't we know who can be a spouse? So that was the reason to pick up the provisions for capacity to marry, ceremony of marriage, and put them back in the code. And further, the very next part of the code talks about the parental background of children. And it says the rights of legitimate children. But the code at present doesn't talk about how people get married. So that's an example where core principles relating to the marriage relationship are in the code, and the committee said, well, we should really put back the definition of marriage. So that was the rationale for bringing those provisions back. Now, the group that are now under discussion are those that are in the consequence bill. Primarily, they are sections 40 to 80 of the Civil Status Act. However, there are one or two exceptions, but basically those 40 sections are now 144 to 164 of the code. And
as was or amended?
Basically, as was, subject only to the modernising of the language. And we had earlier today discussions about why the whole book, when substantive or substantial changes are only made to small portion of the articles. It was explained that this had a structural rationale. For instance, a provision looked at this morning says the residence of a person shall be the place in which he resides. Now, the modern pattern of drafting is to be gender neutral. So if it were done piecemeal, you would have language which didn't specify male or female, but if that article remained, you read it as a whole, so, oh, that only applies to men, not to women. So you would be between styles, so to speak, and the committee was of a view that the modernisation of language, the equality of application should be thoroughgoing. So that's prime reason for having the whole document, even though substance is limited, substantive change is limited.
Okay. Yes, Honorable Kalawan.
Mr. Chair, I go back to 1471C. I have a problem with that. Because A makes it clear. Okay? You cannot get married between all ascendants and descendants, persons related by marriage in the same line. B, the collateral line between a brother, sister, and between persons related by marriage in the same degree. C recognizes that a marriage between a man and his niece or a woman and her nephew actually fall within A or B, or A and B, in fact. But what the court is doing is giving a judge the possibility of making this possible. So, for me, it does not make sense. It does not make sense because it is still a man marrying his niece. And this is the principle. The principle is to protect the family line or whatever. So why should a judge be allowed to undo the principle and allow them to get married? I think this is hypocritical. I think C should go altogether. Well, okay, or well, but the first part is covered in A and B, so it's not only the proviso that should go, but the whole C, because.
It's not collateral, it's a third category. It's a third category. It's not up and down, it's not across, it's like that.
So what you're saying is a man and his niece does not fall in A and B?
No, it doesn't. A and B is up and down. Collateral is horizontal, brother, sister. Niece is down, across, and down. So it's across and down. So it's a combination of A and B.
Okay, so in that case,
Yeah, you remove the last part.
yeah, but okay, now that you've explained this, maybe we should look at it another way. What do we want in our society? Do we want the possibility, go back to the principle. If we are saying it's okay for a man to marry his niece, or for a woman to marry her nephew, if this is the principle, then we don't need to go to court. If this is what we want. But if we say, no, a man should not be allowed to marry his niece, or a woman her nephew, then we put that down, we stop at nephew, and we beef out a judge in chambers for serious reasons. So I think we need to look at what we want, and from there.
Thank you, Honorable. Honorable William. Mike.
Thank you. Thank you, Mr. Chair. In addition to what the Honorable Leader of the Opposition has said, I mean, what are the possible serious reasons to entertain this? I mean, this would be good for us to have an idea.
Okay, thank you. Honorable Afif.
I wanted to ask the question, well, two. One, are these provisions basically extracted from other legislation as they were
Yes.
amended? And my second question is it normal in legislation to give the judge such a large discretion? Because I would have thought the judges normally are asked to make a ruling on A or B, and it is up to the judges to convince them it's either A or B, and he makes a ruling. But he doesn't have discretion. So is it normal to have that kind of discretion being given to judges and legislators?
It is the norm in matters of family matters. It is, for instance, the rule in division of property on divorce. The judge currently has a discretion, complete discretion.
Okay. Thank you, Professor. Honorable Wao.
Again, if I may, presently our law under Section 45 of our Civil Status Act does allow for a niece and an uncle to get married, but that discretion is given to the minister. The decision is given to the minister. Now we're saying it's a judge who has to make that decision. But I do agree 100% with Honorable Ramkalawan that I don't believe we should allow that in our present society. And a question I would like to put to the professor: what about cohabitation? Okay, cohabitation. Are we preventing? We are now recognizing cohabitation, giving legal effect to it. Are we going to recognize a cohabitation relationship between a niece and an uncle? If we're going to do that, then it is hypocritical that we're saying that they cannot get married. But if we're saying they cannot get married, we should also not recognize such common law relationship. And this is what my sense would be. Either way, whether by marriage or by common law relationship, we should not be recognizing such relationship.
Maybe just to, in that case, because we are declaring ourselves a monogamous society and we are not recognizing polygamy, then if we are recognizing common law relationships, again the same thing should happen. That a man and a woman can be engaged in one common law relationship, or else we will be giving one superiority over the other.
Yes.
And then we need to set up a special police squad.
I think one of the reasons for such marriage would be a little bit of what we said for a minor. But we have to look at what is the legal effect of marriage. It's to create rights and obligations. And if we are to prevent an uncle and a niece from getting married, then as Honorable Wawo said, and taken by the leader of the position, that then we should also have a restriction, therefore, with regards to emménage relationship. Because, but however, it will be a harsh reality for the person who, an uncle and a niece, who has been in an emménage relationship for many years, who out of that relationship, children has been born, property has been bought, and when he goes to court for the termination of the relationship, the court says, you pass à la loi passe à vous, without notice. Because this was a position under the old law. Les concubins passent à la loi passe à eux, and without taking notice of them. So we have to be also careful into shutting the door. Well, not even putting a door, is putting a wall, and nobody will be able to climb. So no, I'm just putting this. I'm not saying this is my position. I'm making certain points only for you to toy with these ideas. Is you're going to erect a wall, and that wall, no one will be able to climb. And finally, you will say, the children are victims. They end up not being able to inherit because, well, they would, unless there's a will, or the pauvre concubin will not be able to benefit. So these are things that we have to take into account.
Honorable Henri.
Thank you, Mr. Chair. Now, this morning we learn a brief history of the Code Civil and where it comes from from France. Now, that was there way back then in 1800, and even further than that. And then that code, when it was revised in 1975, we were told that it was said, make it as Seychellois as possible. So today, as Seychellois, I'm sure all of us around this table would not accept this thing, uncle marrying niece. This is not us. It's not Seychellois. It's not Seychellois Catholic or even Anglican. Don't do this thing. So I'm not in favor of this, definitely. And I wanted to ask one question, Mr. Chair, with regards to 1442A. 1442A, the definition of friend in this article. Thank you.
Okay. Thank you, Honorable Henry. Honorable Pile.
Thank you, Mr. Chair. Mr. Chair, Honorable Wawo has quoted the Civil Status Act twice, so maybe if we can be guided, those of us who are not lawyers in the room. Which came first? I believe the Civil Code came first. And in that respect, I believe that everything that was in the code was just transported over to the Civil Status Act, and that is why we have the problem. In regards to this particular act, I raised that point because when the professor talked about history, I think a little bit of research that I did showed me that during that time when the Code Napoleon was being set up, there was a fear of losing property across families. So therefore, they married the properties within the families so that they could keep the properties. But the whole historical context today has changed, and as my colleague has so eloquently explained, this doesn't represent us. So I think this provision should go, that's why I raised the point initially. But in regards to what the AG said, I mean, buying a property still means that the property is mine. And so if I have declared the child is legitimately owed the property, whether that child is in a wedlock or not, he still owed the property because he is my direct heir. So that he retains that right by virtue of that. So I don't think we are affecting that as such. I think that that provision we should go over with that provision once and for all and clarify things. Thank you.
Yes, Honorable George. Okay, I'll pass on to Honorable Adel first.
Just a small, AG has said that we are putting a wall that no one will be able to climb except by way of will. And in this very same code, we are having testamentary freedom. So, I believe this will be one way of educating most individuals or our population that a will is something that is advisable to do because we would have the freedom of giving it to the church or distributing it amongst the children in house. Thank you.
I think, if I may.
Yes.
I think there is also one issue that to bring a new import in this code, in this draft bill, is the fact that a child born within the relationship, not even a where the parents are not married, the father, the partner, the male partner, is presumed to be the father of the child. So this is we've gone a long way, and I take it from what Honorable Wawo says. It might be hypocritical, because at the end of the day, I'm on the issue. Two persons who are related, and there is a child. They've been living together. Automatically, the child becomes. Professor would not like me to use this word, but as it is now, the child is sort of enfant légitime, okay, legitimate child to some extent. So we have also to take this into consideration. It's a departure from today, where it's only the husband of the mother of the child is the father of the child. Whether biologically the father, the husband of the mother is the father of the child, but so long as they're married. But now we're going a little bit further.
Yes, Honorable Modo. Let me come back to you, Honorable George.
Thank you. My question is, what is the spirit of the provisions in what we're discussing today? one of the spirit is to protect what is good in our society, but at the same time, we need to curb down on certain behaviors that is not good in our society. So I want the committee to tell us, is that one of the spirit that you look at, the behaviors that are destroying our society, which is not good, which is not acceptable? Are we looking at that as well? Because this is what we're discussing at the same time. Marriage between a niece and an uncle. So we need to make decisions on trying to curb down on things that we don't want in our society. Thank you.
Thank you. Honorable George.
Thank you, Mr. Chair. I can see that if this debate continues much longer, the next thing to be done is that we're going to criminalize adultery, and then have a religious police to go around find out who's having sex with who in our society. That was a joke for those people out there who are listening to me. The point I wanted to make was this: the historical development of the code is to be found in this context in religion. In the Roman Catholic Code and in the Book of Common Prayer, there are rules of affinity and consanguinity. So marriage is prohibited in a whole list of degrees of consanguinity or affinity. And what the code does is to reproduce that in a certain sense. So there is a historical context. And of course, I totally agree. The historical context of Seychelles has changed from that which existed in France in 1804, which is the whole rationale behind modernizing the code. This was by way of introduction to ask us to also look at Article 147.2 while we're at it. Do we think that in the context of today, that a person can marry his wife's sister when his wife dies, and vice versa? Is this something that we find is acceptable? Okay, so well, so is slavery, so is stoning, but we don't.
Yeah, it seems that everybody was forgetting about 147.2. Yes.
I don't know, but Mr. Chair, I don't see any problem with a man marrying the sister of his deceased wife, because I mean they are not related by blood. No, they are not. I mean the marriage, the marriage of the man ends with the death of his wife. So, and I think okay, we've seen that in our society, and
he's got a point. What will happen now in the second marriage if children are born?
No, but the children. No, that's not an issue.
So the children would just be cousins.
Yes, and these are things that happen. I mean, well, no, but the important aspect is the marriage. The first marriage of that man or the woman has ended, and therefore the man is free to marry whoever, whether they be brothers, half brothers, at the same time cousins. I mean that's another matter which does not go back to the original point. And as I say, this is very biblical. In fact, in the Bible, a man has the duty to marry the sister in case of death.
Honorable George, have you come across any during your career, your long career?
Yes, yes. I think I think we're giving away no secrets when we say that Louis Vanchard, who we spoke about earlier, who has written a number of books together with Professor Angelo, and who used to be a judge of our Supreme Court here, married the sister of his widow. When Thérèse, his wife, died, his widow was unmarried, and it was felt in society that to go to the end of your life without getting married has a bit of a stigma. So he married her. So it does happen. Yes, we've seen it.
Okay, thank you. You want? Yes.
Just sorry.
Okay, if you want to make final comments.
Yep. Very briefly, some of the
definition of friend.
yes, very briefly, a significant moral, if you like, impulse behind these restrictions on close marriage with close relatives by affinity, by marriage, is so as not to disturb, at least during life, existing relationships. So the fact that you could not marry your wife's sister was seen to stabilize the marriage, because you wouldn't think, you know, this partner is aging and the other is younger, and so you switch allegiance, male or female, and it was in order to protect that formal close group. They said no marriage between these links by affinity. And then you have the death situation, and again, I suspect we're back to protecting family property, which is then the exception in paragraph 2. The other question is, friend is new. There is nothing similar in the present. It just says that the minor may come to the minister and ask for a dispensation. And the committee's view was, in some of these cases, the situation is serious for health or other reasons. The minor personally may not be in a good condition to make the application, and if the guardian is against it, then the thought was the application should not be precluded. If they have a good friend who's prepared to support them in making the application, then it should, the ability should still be there.
Can the friend be a minor?
Take the mic.
No indication, but one would expect the judge to be wanting an adult in order to determine the seriousness of this matter.
It has to be.
I think there's a small problem there. If
husband to be also can pass on.
well, the explanation that Professor has given
Has to be
us,
an adult.
and
But what about just say
when I read 144.2a, the consent of a judge to a marriage may be given on the oral application of the minor. Okay? I don't see how or why we should extend that to the application being made by a friend of the minor. I think this is something something personal, because in any way probably the friend will need the consent of the minor to make the application.
Yeah.
So if the friend will need the consent of a minor, so why can't the minor do it himself or herself? I think
They may.
Yeah, so I don't see. I think it should end with given on the oral application of the minor. Full stop. But anyway, we are biffing marriage out altogether. But
yes, point taken.
So you. All right, shall we?
Are we done with marriage? Have we? If we've finished this whole chunk of marriage, I would just like to point to two things. First of all, if you go to Article 160, you will see an example there of where we have retained a French word. We've done this, or we've proposed doing this throughout the code, where the word act and the old French word act, the English word act and the old French word act don't have necessarily the same meaning. So we've kept the old French word so that for lawyers who go back into the jurisprudence, they can be guided accordingly. And I just like, because it's a matter of personal interest, 1602, contrat de mariage. The deux de mariage will have to be split.
Yes.
But that's another example. And then I just wanted to, last week we had a long debate about marriages and whether local people getting married at the civil status office have to pay a fee or not. I'd like to bring to our attention that under Article 162, each one of us here can give a dispensation, can write to the civil status officer a letter asking that the fee, which is non-existent, be waived in cases where our constituents cannot afford to pay the fee to get married. The whole purpose being to facilitate marriage rather than to put an impediment to it. So if we've got to 210, our next section is the dissolution of marriage, 211 until 237. And if we want to take nullity of marriage as well, because they are related, we can go all the way up to 243. And if we want to add separation to that, we can go to 245.
Even the relief.
In between 147 and 210, anybody's got any query? Yeah? Honorable Wanwo, then Honorable Afif.
It's regarding the arrangements of the articles. Presently, in the present civil code, it's now chapter 5, and it says the obligation arising from marriage, okay? And that is from Article 203 until, I believe, Article what will be now Article 210. So even our present Article 203 is similar to the one that is being proposed, okay? And just for purpose of clarity and to make it more friendly, reader-friendly, or for us lawyers, should we not have in the arrangement of articles where we have, okay, for instance, we have dissolution of, we have marriage, and then we should break from we have articles 144 to 210, marriage. Now, should we not have 203 to 210 and say obligations arising from marriage? Because this is what articles 203 to 210 deal with. So it will make it easier for us when we are referring to the arrangements. Yeah.
Subheadings.
Yes, exactly. Mm-hmm. In the arrangements.
Yes. Yes.
Yeah.
Honorable Afif.
I just wanted to ask whether the panel could assist us, just for clarity purposes, to tell us what clauses we're looking at specifically and what has changed from what existed before. Because we're just going over sections, okay, we're done with that, but we're not very sure what has changed that we need to focus on. Because finally we're changing something, and the public out there wants to know what has changed that we we just removed.
Yes.
So if you can highlight to us and help us by looking at the numbers and saying, okay, 149 is a change compared to what existed before.
Thank you, Honorable. Honorable Modo.
Thank you. I just want to know if the committee had, during the meetings, people coming up with provision for marriages between two men. Because when we're talking about two men, because there's no, this is silent, but I just want to know out there, was that an issue? Was it discussed? I just want to know if that.
I think whilst we yes, it is not silent. In fact, we've had we had some long discussions, myself and Honorable George, but I've just together with Mr. Domain, it's a ground for nullity of marriage. It's a ground for nullity of marriage if a marriage is. There are a few provisions in the code that more or less makes it clear. For example, with regards to the 238.1d, the parties of a marriage were not respectively male and female. So this will disqualify. Will annul a marriage of two persons of the same sex would be subject for annulment, nullity of marriage, 238.1d. And then with regards to a relationship, an homenage relationship, if we go to 259.6, it says a qualifying relationship means either a marriage, and then, or a domestic relationship, homenage, between a man and a woman of full age and capacity characterized by stability and continuity. So it takes care of a few of our arguments recently.
If I may, yes, it was something that was considered, and naturally it was something that the committee had to come to grips with and make a decision to stay with the status quo, which was decided, or to go further. And there are two steps which could have been taken. The first one is to equate a civil law relationship, i.e. an homenage, with a marriage, as occurs in many other countries, so that if you've lived with somebody in a civil relationship, that has the same consequences as a marriage. And the other was to address the issue of same-sex couples living together. And the committee decided that it was too much, too quickly. So the committee limited itself to the distribution of property when an homenage relationship ends. We didn't go any further. And this will come later. And it has been felt in discussion that perhaps this is not a matter that must be tested by legislation at this point, but it must be something that should be tested in the Supreme Court. Why do I say that? We have a constitution which has an equality provision before it, and sooner or later, persons wanting to get married, two persons of the same sex who want to get married, will test that equality provision and will go to court and will argue that the law must provide for full equality and therefore they must be given that permission. That is something that we thought at this point should be done by the court with full arguments one way or another. The court will accept or the court will refuse to accept, etc., before the legislature is called upon to pronounce itself on it.
Yes, Honorable Basil.
I do understand the point made by Honorable Mondon. There is a distinction. Article 147, the proposed Article 147, talks about prohibition in respect of certain marriages. Article 238 rather, addresses the issue of declaring nullity of marriage which has already taken place. Yes. And what it is saying now, it is saying that if a marriage has taken place between two men, it can be annulled, can be declared a nullity. But I believe we should include in Article 147 a prohibition altogether. We should include a prohibition altogether in Article 147 because it prohibits, full stop. Because if you look at the different elements as to what will render a marriage nullity, it will be where there is a marriage which is recognized by law, which has taken place, but certain things have happened. For instance, it says the marriage was not celebrated in accordance with the code. The respondent was, at the time of a marriage, pregnant by some other person other than the petitioner. It is a marriage which has been properly celebrated, but issues has arisen which maybe were unknown to the parties, or whereby the marriage has not been celebrated in accordance with the law. But if we want to prohibit between the same-sex marriage, then we should say so under Article 147. And we have to bear in mind also, Article 32 of the Constitution. 32 regarding protection of the family. And that sub-article 2 of Article 32 does provide that a law may prohibit same-sex marriage. Yeah. And such a law will be within the ambit of the Constitution.
If I may, Mr. Chair, yes. I think this is a very, very important issue, and before we go back to the code, it's something that we need to address. You see, as of today, there is only one place in the law which indirectly speaks of marriage being between a man and a woman, and that is in a small law called the Summary Jurisdiction Wives and Children Act, and it only concerns maintenance of wives and children. And it makes that reference. It doesn't exist anywhere else. What Honorable Wao says is correct. Article 32 of the Constitution says, if a law is passed tomorrow, there isn't one, but if a law is passed tomorrow saying that marriage must be between a man and a woman and cannot be between two people of the same gender, that law will not be unconstitutional. That's all it says. Okay? That's all it says. It says if a law is passed, it will not be unconstitutional. In other words, the framers of the Constitution have already said that if you decide to pass such and such a law, it will not contravene the Constitution. Although it is open to argument as to whether it will contravene Article 27, which is the equality provision. That's not a matter for our debate today. We can take the whole rest of the week for it. It's a very interesting debate. It is one which will be tested at some point in the court. And I can say this because I know that steps are being taken for this argument to be brought before the court. So let's not preempt what might happen there.
And we can see.
Sorry, what the nullity provision does here, and we need to consider that under 238. What the nullity provision does is to say that it doesn't say that if two people of the same gender get married, that marriage is null. That's not what it says. It just says that if two people get married and then it is found by one of the parties, because I can't go to court, I have to have locus standi. I can't go to court and declare the marriage of Honorable William void. He has to do it. Marriage and nullity is personal. So if I get married, and in fact this arose because of the famous case of Corbett and Corbett in the United Kingdom, where they got married, Mr. and Mrs. Corbett got married, and later on, Mr. Corbett found out that Mrs. Corbett was actually born a man but had a sex change. So that prohibits, that allows you to nullify the marriage, because a marriage, in terms of nullity, has got to be between a man and a woman. So if you find out later, you can get the marriage nullified, annulled, along with a number of other reasons. But it doesn't say that if two people get married tomorrow, for instance, let's say two men go down to the civil status office, the civil status officer marries them because he or she cannot find anything in the law that says not to marry them, that any one of us can go to court tomorrow and declare their marriage null. I know what Honorable Wao is going to say. He's going to say that the law as it currently stands says on an application. It doesn't say that one of the parties has to apply, but I think we have to infer. I can't accept that Honorable Wao can go to court tomorrow and say that let us say, for instance, that I have committed a matrimonial offense and that my wife should be divorced from me because I have done that. let her apply. You see, so it's the same. So it's the same thing. It's the same thing, I think, for nullity. But as I say, it's a very sensitive subject, and it is one which I would dearly love the Assembly to debate, because it is a matter of importance, and it is a matter that will keep coming. Let us not forget. It is a matter that will keep coming. But should we do it now?
Yeah, the marriage in the code that we are actually moving into, I mean, reviewing, modernizing, and all that. What does that marriage mean?
Well, good question, and in fact, I haven't addressed. Honorable Wao says, let us once and for all write into the code that a marriage must be between a man and a woman. That's a completely different thing. And if it's the consensus of everybody that should go in, well, that is something that is within our power to do.
Honorable Wao?
Actually, I do believe Mr. George, Honorable George is right on one thing. A third party cannot make an application to declare a marriage nullity. Okay, you must have a vested interest. Either it's the party themselves or somebody else who has an interest in that marriage. Either if a person has committed bigamy, then the person who is already married to one of the spouses, he can make the application. So this is my fear. My fear is that two persons of the same sex, they get married, then nobody will challenge it before the court, because nobody has an interest to do so, and that marriage will subsist. This is my fear. This is my fear. And what Honorable George has stated, right now it says it is a nullity. According to Honorable George, it is only if one discovers at a later stage that the other party to the marriage is of the same sex as a person making the application. But I don't believe that this has been translated in the present wording of Article 238 1D.
I think you're right. I don't want to limit it to that.
Yeah.
I agree.
Okay.
Two people can get married today.
Yeah.
Men and men, and then they fall out in a year's time. They can go to court under this.
Yeah.
And get it done.
Exactly. Even if they knew at that time. Exactly. So, but this is why I'm saying that, because only the two parties will be able to bring an application, and nobody else, even though we know that the law can render such marriage declare it a nullity, yet because nobody will have a right to make an application, that marriage will subsist. The only way we can prevent that from happening is that by including it under Article 147. This is the only way. No, it's not, because I believe Mr. Honorable George is saying that there will be a constitutional court case challenging the prohibition of same-sex marriage under in terms of equality of the law. But Article 32, the Constitution itself, makes provision that there might be such a law. There may be such a law.
Okay. May I suggest we take a break and we go for a tea? Because I've got VP waiting for me upstairs.
Yes, but, Mr. Chair, I think the debate is getting interesting, and even out there,
you're getting bashed.
It's I'm getting bashed because I said that a man can marry his sister-in-law, but maybe it is. I would urge patience on the part of of our dear people of Seychelles. This is a debate. This is a discussion.
Yes.
There will be times when I mean, just like the last statement that Honorable Wao said, this is all part of the debate. I mean, the last thing we want now is for the gay community to start saying, here is Mr. Wao, Honorable Wao, blah 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 blah. I mean, just to urge our people, please approach this whole exercise with an open mind, because unless we put everything down on the table, we will not get anywhere. And I would just say to the person who is of a strong evangelical background, to please go back to her Bible and read her Bible, and she will find that what I said is biblical. And in fact, the Sadducees tried to catch Jesus over this very issue. Thank you.
Okay, one small remark and then we break.
Thank you very much. Who establishes the person who has interest? One issue that was raised by who establishes, or how does the interest fall in? Because the interest is not clear. Is it only one or the other? I'll give you a typical example. Articula mortis. If a child who believes that the provisions of the law has not been complied with, are they an interested person?
I think I'm of the view that this provision 236 can be interpreted just like Honorable Wawa said, and as Honorable George. But we should not lose sight of the fact that this provision has been in our law for a long time. It's under the Matrimonial Causes Act. And I do not think, when you look at this provision, it is more that I go through a marriage ceremony with a woman, but eventually I discover that that person had had a sex change. So she was not a woman. So this gives me ground for me to have the marriage annulled. So I would have interest. But Honorable Ade, I think you're trying to say, if there were two persons of the same sex has gone through civil status, celebrated the marriage, now who will have standing, would be able to make an application? If me, busybody, I wake up one day and X and Y has got married, I go to court and I said, no, this is against the morals of this country. Whether the court will entertain me or not. Or whether, as Honorable George said, two persons of the same sex they get married, and 10 years after they've lived together, have a sort of a property, adopted children, let's assume, and then they decide to say, no, we want the marriage annulled. Whether the court will allow them to do so. Because otherwise it will be an easy way out for them. So either there is a restriction now, which is under Article 32, this is permissible under the Constitution, or we leave it as it is, and eventually Mr. George brings a case for a litigant to the Constitutional Court and claim that there is no equal protection under the law.
Okay. The French make the distinction between nullité relative and nullité absolue. When you have nullité absolue, anyone can bring an action. It's contrary to an imperative provision d'ordre public. So anyone can bring an action. Whereas nullité relative, the people concerned. And I think this one calls nullité relative. It's not anyone who can bring it. It's the parties concerned. Yeah.
Okay. Yes, thank you.
It's not anyone who just say it's contrary to the law, because it's nullité relative, absolutely.
Thank you. Members and panelists, we'll take a tea break. We'll take a tea break. We come back at 4:15. No, I've got VP. I've got a meeting with VP. Yes. Okay? So 4:15 we resume. Thank you.
Thank you.